Denzel Washington stood poised and unshaken at the lectern in Supreme Courtroom 3, his sharply tailored navy suit cutting a striking figure against the grandeur of the marble columns towering behind him. Moments earlier, Chief Justice John Roberts had delivered an unprecedented and pointed challenge. "Mr. Washington, I find it difficult to believe that someone with your background fully comprehends the constitutional ramifications of your position." The courtroom fell into a stunned hush. Law clerks exchanged startled glances, seasoned attorneys leaned forward in disbelief, and journalists raced to capture the moment in their notes. But Washington, known to the world as an acclaimed actor, remained unfazed. Unknown to many, he had spent the last 5 years quietly pursuing a law degree while balancing a career in Hollywood blockbusters. Chief Justice Roberts, with his Harvard credentials and nearly 2 decades of experience presiding over the nation's highest court, appeared confident that he could dismantle what he presumed was a performative legal effort from a celebrity. But what followed would upend every assumption. Washington began to speak, articulating a constitutional theory he had spent years refining, one deeply rooted in jurisprudence and fortified by a mastery of precedent. His argument didn't just hold, it captivated. It was a turning point not just in the case, but in the perception of who is deemed worthy to stand before the highest court. This was no ordinary hearing. It was a historic moment in American legal discourse, a brilliant legal rebuttal delivered not by a traditional scholar, but by someone who had defied expectations. Denzel Washington wasn't just defending a position, he was redefining what a constitutional advocate could look like, and the court would never forget it. Before we dive into this extraordinary courtroom moment, don't forget to like this video and subscribe to our channel for more compelling stories where preparation meets purpose and unexpected voices reshape the legal landscape. The atmosphere inside the Supreme Court had been electric for weeks, ever since the name Denzel Washington appeared on the YK docket. The Hollywood legend had filed an amicus brief in Henderson v. Department of Justice, a pivotal case challenging civil forfeiture laws that disproportionately impact minority communities. At first, legal analysts dismissed it as mere celebrity posturing. But beneath the surface was a revelation no one saw coming. Washington had quietly earned his Juris Doctor from Howard University School of Law, balancing late-night study sessions with demanding film shoots. He kept the achievement entirely private until now. Presiding over the courtroom was Chief Justice John Roberts, 67, a pillar of legal tradition. A Harvard Law alumnus, former clerk to Chief Justice William Rehnquist, and once the nation's principal deputy solicitor general, Roberts had built a career on rigorous legal analysis and a sharp command of oral arguments. His pointed hypotheticals and surgical questioning were known to unravel even seasoned attorneys. So when Washington was granted a rare 10-minute slot to speak in support of the petitioner, an unprecedented move for someone submitting an amicus brief, the legal world buzzed with speculation. Most assumed it was a symbolic gesture by the court to appear more relatable to the public. But for those who actually read Washington's meticulously crafted 40-page brief, it was clear this was no PR stunt. It was the work of a serious legal mind, disciplined, insightful, and deeply informed. And soon, the world would see that this wasn't just a cameo on the national stage. It was the beginning of a legal reckoning led by someone who had prepared in silence and was now ready to speak with purpose. The brief Washington submitted contained a bold and innovative legal theory, one that reinterpreted the original intent of the Fifth Amendment's takings clause in a way that directly challenged decades of entrenched precedent. "I can't believe they're actually letting him argue just because he's famous," muttered a corporate attorney to a colleague seated nearby in the gallery. "This isn't Hollywood. You can't just memorize lines and expect to persuade the Supreme Court." But this was no script. The stakes could not have been higher. At the heart of Henderson v. Department of Justice was the government's controversial seizure of a community center and surrounding homes in a predominantly black neighborhood in Philadelphia. The justification? A single drug transaction, committed by someone unrelated, had taken place on the sidewalk outside. Despite the absence of any criminal charges against the property owners, the federal government had invoked civil forfeiture laws to confiscate millions of dollars in real estate. Washington's argument aimed to establish a precedent that would severely restrict the government's ability to seize private property without a corresponding criminal conviction. It was a direct confrontation with a system that had, for years, disproportionately harmed vulnerable communities. If he succeeded, the ruling could reshape property rights jurisprudence and strengthen protections for countless Americans. But if he failed, it wouldn't just be the properties lost. His years of disciplined legal scholarship could be dismissed as nothing more than the overreach of a well-meaning celebrity dilettante. For Washington, this wasn't just about the law. It was about legitimacy, legacy, and justice. The courtroom held its breath as Denzel Washington stepped toward the podium. Unlike many first-time advocates who faltered under the gaze of the highest court in the land, he carried himself with a calm, collected presence, and ease born of years under the brightest spotlights. Yet even with that poise, few in the chamber could have predicted just how meticulously prepared he was. "Mr. Chief Justice, and may it please the court," Washington began, his deep, resonant voice filling the ornate chamber effortlessly, without the need for a microphone. He launched into his argument with clarity and conviction. The Fifth Amendment's command that private property shall not be taken for public use without just compensation, he explained, was, in the founders' understanding, not limited to financial restitution. It demanded a legitimate public purpose and fundamental procedural safeguards before the immense force of government could be used to deprive a citizen of their property. His introduction was articulate, measured, even impressive, but not yet extraordinary. Chief Justice John Roberts, reading the brief earlier with a degree of skepticism, saw what he believed to be an opening. Eager to test the substance behind the celebrity's legal claims, Roberts did something unusual. Breaking with the court's typical decorum of allowing uninterrupted openings, he interjected just 40 seconds into Washington's presentation. "Mr. Washington," the Chief Justice said, his voice laced with polite condescension, "while I appreciate your engagement with this matter, I find it difficult to accept that someone with your background fully grasps the constitutional complexities of your argument. Your brief, while certainly ambitious, appears to disregard nearly 2 centuries of settled precedent on civil forfeiture." The room reacted instantly. A hushed murmur rippled through the gallery, seasoned attorneys, clerks, and journalists all aware of the unusually personal nature of the challenge. This wasn't just a legal test. It had become a trial of credibility, intellect, and identity. And Washington, unshaken, was about to respond. Justice Sonia Sotomayor shifted slightly in her seat, visibly unsettled. Justice Elena Kagan's brow furrowed as she leaned in, her expression growing more intent. At the podium, Washington paused, then lifted his eyes to meet Chief Justice Roberts with unwavering calm. Those familiar with him recognized the look. It was the quiet stillness that always came before one of his most commanding performances. "Chief Justice Roberts," Washington responded evenly, his voice steady and unflinching, "I believe my argument aligns with the historical understanding of the Fifth Amendment, as expressed by Justice Thomas in his concurrence in Timms v. Indiana. But if there's any doubt, I suggest we walk through the textual and historical evidence together." With that, he opened a well-worn pocket copy of the U.S. Constitution, accompanied by a collection of original source documents, materials few advocates ever brought into that courtroom. His move was deliberate, confident, and deeply researched. Something in the precision of his preparation caught Roberts off guard. This was no shallow performance. This was not celebrity grandstanding. What followed was the opening salvo in a cerebral legal duel, one that would unfold like a masterfully played game of chess. And by the time it ended, both the court and the country would be forced to reckon with what they had just witnessed. Realizing that his earlier attempt to undermine Washington had failed to shake him, Chief Justice Roberts shifted tactics. He leaned forward, this time ready with a more substantive legal challenge. "Mr. Washington," Chief Justice Roberts began, his tone sharp and probing. "Your brief contends that the original scope of civil forfeiture was confined to admiralty and customs cases, where courts lacked jurisdiction over property owners. But you've neglected the Palmyra, an 1827 decision where this court clearly affirmed broader government forfeiture powers. It was a classic trap, one that had ensnared even the most seasoned litigators. The Palmyra was a pivotal forfeiture case, but its complexity was often misrepresented." Without missing a beat, Washington replied calmly, "With respect, Chief Justice, I have not overlooked the Palmyra. In fact, I addressed Justice Story's opinion in depth on page 23 of my brief." He turned directly to the page without so much as glancing down. "As you'll see, the Palmyra did allow forfeiture without a criminal conviction," he continued, his voice growing stronger, "but it was strictly a maritime case involving piracy. Justice Story clearly stated that the vessel itself was considered the offender. That legal fiction was necessary in admiralty contexts, where personal jurisdiction over ship owners was often unattainable." Washington paused, letting the distinction settle in. But Justice Story never implied that this narrow exception should evolve into a general rule for domestic civil forfeiture, particularly not when dealing with American citizens who are fully within the jurisdiction of our courts. He leaned slightly forward. In fact, I conducted a comprehensive review of every civil forfeiture case decided by this court from 1789 to 1850, 27 in total. And every single one involved either maritime seizures, customs violations, or acts of piracy. Not one extended forfeiture power into the realm of domestic property unrelated to those exceptional contexts. It was no longer a courtroom surprise. It was a masterclass in legal history, and the justices knew it. Not a single case, Washington noted, had ever endorsed the kind of land-based seizure from innocent owners seen in Henderson. The courtroom fell into a tense silence. This wasn't just a man who had read the Palmyra. Washington had undertaken a sweeping historical analysis that surpassed the efforts of many legal scholars, let alone practicing attorneys. Justice Samuel Alito, known for his deference to law enforcement authority, leaned forward. "That's an interesting historical perspective, Mr. Washington," he said. "But how do you reconcile it with this court's more recent precedents? In Bennis v. Michigan, we upheld the forfeiture of a vehicle owned by an innocent party." Washington didn't hesitate. "Justice Alito," he replied, "I believe Bennis was wrongly decided." A collective gasp rippled through the gallery. To directly challenge binding Supreme Court precedent, especially in open court, was a bold and rarely attempted move. But Washington stood firm. "And I'm not alone in that view," he continued. Justice Thomas, joined by Justice Ginsburg, despite their vastly different jurisprudential philosophies, authored a powerful dissent. They understood the core issue. Bennis introduced a doctrinal inconsistency that this case offers the court an opportunity to finally resolve. He calmly flipped to a new page in his notes. Since Bennis, the court has handed down Austin v. United States, which held that civil forfeiture is constrained by the excessive fines clause, and Timms v. Indiana, which incorporated that protection against the states. These rulings recognize that civil forfeiture is not merely administrative. It is quasi-criminal and therefore subject to core constitutional safeguards. Around the chamber, the mood shifted. What began? Justices who had initially regarded the argument with skepticism were now fully engaged, several leaning forward, taking meticulous notes. Court observers noted with surprise that Justice Clarence Thomas, known for his silence during oral arguments, appeared especially attentive. Then Justice Brett Kavanaugh entered the discussion. "Mr. Washington, your historical argument is compelling," he said. "But let's talk practicality. Civil forfeiture is a vital tool for law enforcement. Are you proposing we do away with it entirely?" "Not at all, Justice Kavanaugh," Washington replied without hesitation, urging the court to return civil forfeiture to its original constitutional boundaries. It remains entirely appropriate in traditional contexts, admiralty, customs enforcement, in cases where the government cannot establish jurisdiction over the property owner. He continued, his tone measured but firm. But when the state has the ability to bring criminal charges and chooses not to, yet still moves to seize a person's property, then both due process and the takings clause demand a higher threshold of justification. Chief Justice Roberts, visibly intrigued and perhaps surprised by the depth of Washington's command, attempted a new line of questioning. "Your brief references several obscure, founding-era state court decisions that few scholars have seriously examined. How can we be sure these represent the prevailing interpretation of the time, rather than isolated outliers?" It was a classic test, a question designed to catch poorly sourced arguments or cherry-picked evidence. Roberts appeared to suspect that Washington had built his case on fragile academic ground. Washington gave a faint, confident smile. This was the moment he had anticipated. "I'm glad you asked, Chief Justice," he said smoothly. "Far from being anomalies, those cases reflect a strikingly consistent pattern across early American jurisdictions." Without glancing at his notes, Washington proceeded to summarize the facts, context, and holdings of 8 separate state Supreme Court rulings from the early Republic. He detailed how these decisions collectively reinforced a narrow and principled view of legitimate government seizure, one deeply anchored in the founders' understanding of property rights. Justice Elena Kagan, clearly impressed, leaned in. "Mr. Washington, your historical research is extraordinary. Did you collaborate with a team of legal historians to prepare this argument?" For the first time during the proceeding, Washington allowed himself a small moment of pride. "No, Justice Kagan. While I certainly consulted the work of leading scholars, the primary research, tracing those cases through archival materials and examining the original court documents. I conducted myself. During my years at Howard Law School, and in the time since graduation, the courtroom was silent again, but this time with reverence. A quiet buzz spread through the courtroom. For many in attendance, it was the first time they realized Denzel Washington's legal credentials were not just symbolic. They were substantive and hard-earned. Chief Justice Roberts, whose earlier tone had bordered on dismissive, now appeared visibly uneasy. Sensing a shift in the moment, Justice Sonia Sotomayor leaned in and seized the opportunity. "Mr. Washington," she said, steering the discussion back to the case, "how does your historical framework apply specifically to the community center seized in Henderson?" Washington turned toward her, his expression calm and focused. "Justice Sotomayor," he began, "under the original understanding I've laid out, the government's actions in Henderson violate the Constitution on several fronts." He raised one finger. First, the basis for the seizure, a single drug transaction committed by an unrelated individual on a public sidewalk, creates, at best, a highly tenuous connection to the property in question. He raised another. Second, there has been no attempt by the government to demonstrate that the property owners had any knowledge of illegal activity. A third, the scope of the taking is wildly disproportionate to the harm allegedly caused. Seizing an entire community center based on such minimal justification defies any sense of proportional justice. Then he paused and delivered his most powerful point yet. But perhaps most critically, he continued, his voice steady and resolute. This seizure fails the Fifth Amendment's public use requirement. When property is confiscated and redirected into general government coffers, rather than used to remedy a direct public harm, it cannot meet the public use standard as understood by the framers. His argument had gathered weight and momentum, resonating not only with the constitutional text but also with the conscience of the court. In a rare and telling gesture, court officers quietly extended Washington's speaking time, an unspoken sign that the justices were no longer merely hearing him. They were listening. Chief Justice Roberts was now fully engaged. What had started as a subtle attempt to expose a celebrity's inexperience had backfired spectacularly. Rather than faltering, Washington had risen to the moment, using the challenge as a platform to display legal insight and intellectual rigor that few expected. The stakes had shifted dramatically. What began as a courtroom curiosity, an actor standing before the Supreme Court, had evolved into a profound and serious re-examination of constitutional doctrine. And Washington wasn't finished. The atmosphere inside the chamber had transformed. The initial skepticism that greeted Washington's appearance had dissolved. In its place was a charged sense of respect. His mastery of constitutional history, jurisprudence, and legal theory wasn't just impressive, it surpassed that of many seasoned litigators who had argued before the court for decades. Chief Justice Roberts, now clearly aware that his early tone had not only been dismissive but arguably inappropriate, made an effort to re-establish his footing. "Mr. Washington," he said, his voice more measured, "your historical analysis is undeniably thorough. But I remain concerned about the practical consequences of adopting your framework. If we accept your argument, wouldn't it cast doubt on countless existing forfeiture cases? Have you considered the reliance interest that could be disrupted?" It was a fair question, one that often weighed heavily on the court when considering doctrinal shifts. But Washington had come prepared. "Chief Justice Roberts," he replied, reaching for a document from his case file, "I have carefully considered the practical impact." He held up a report. "This is a statistical analysis I compiled using data from the Department of Justice's asset forfeiture program over the past 10 years. Based on that data, approximately 87% of all current forfeiture actions would remain entirely unaffected by my proposed framework. These include cases involving unclaimed property, customs violations, and forfeitures tied to criminal convictions." Washington turned a page with quiet precision. "The only forfeitures that would be called into question," he concluded, "are those that most blatantly conflict with our constitutional traditions, where property is taken from citizens without charges, without due process, and without clear public benefit. It is precisely those cases that the Fifth Amendment was meant to guard against." The courtroom fell silent once again, not out of doubt, but from the growing realization that something extraordinary was unfolding. Seizures from innocent the properties in question were being seized from their rightful owners based on tenuous associations with alleged criminal activity, often without a single charge being filed. Though these cases account for less than 13% of civil forfeitures by value, their consequences are disproportionately devastating, especially for vulnerable communities like the one in Philadelphia at the heart of this case. Justice Amy Coney Barrett, who had listened attentively throughout the proceedings, finally entered the discussion. "Mr. Washington," she began, "your brief presents a novel textual interpretation regarding the relationship between the Due Process Clause and the Takings Clause, an argument I don't believe has been previously developed in scholarly literature. Could you elaborate on that?" It was a question rooted in genuine intellectual curiosity, a clear sign that Washington's argument had not only earned respect, but was now shaping judicial inquiry at the highest level. "Thank you for that question, Justice Barrett," Washington replied, his tone appreciative and steady. Traditionally, the Due Process Clause and the Takings Clause have been treated as separate constitutional protections. But historical evidence indicates the framers understood property rights as inseparable from procedural fairness. He leaned forward slightly, his voice gaining momentum. James Madison, who authored both clauses, often wrote about the essential link between due process and property rights. In an 1788 letter to Thomas Jefferson, he explicitly warned against arbitrary government seizures, framing them as violations of both procedural justice and the fundamental right to compensation. Washington paused, letting the point land. When the government deprives citizens of property without meaningful procedural safeguards, it does more than deny just compensation. It undermines the very structure of constitutional liberty. That's why these clauses should be read together, not in isolation. Justice Barrett nodded slightly, visibly intrigued. Around the courtroom, there was a quiet but unmistakable shift. Washington's theory wasn't just being acknowledged. It was now influencing the court's own framework for evaluating the Constitution. Washington reached into his folder and carefully pulled out a photocopy of a handwritten letter. "While preparing for this argument," he said, "I took the liberty of visiting the Madison Papers collection at the Library of Congress. This particular letter hasn't been cited in any prior civil forfeiture cases." He held it up, allowing the justices to see the document. In it, James Madison makes a powerful assertion that the seizure of a citizen's land without due process or a legitimate public purpose constitutes, in his words, a double violence against the right most sacred in ordered society. A quiet ripple moved through the chamber. Then, breaking the silence that had defined his presence until now, Justice Clarence Thomas spoke, an event rare enough that reporters immediately leaned forward, pens ready. "Mr. Washington," Thomas said, his tone thoughtful, "your originalist approach is both thorough and refreshing. You've made a strong case that modern civil forfeiture practices stray far from the founder's vision. But let me ask, how would you distinguish this case from Bennis versus Michigan? Are you asking us to overturn that precedent outright?" The question went to the heart of stare decisis, the court's principle of upholding prior rulings unless a compelling reason exists to depart. Washington responded with measured precision. "Justice Thomas, while I believe Bennis was wrongly decided, the court does not need to explicitly overturn it to find for the petitioners in Henderson. In Bennis, the property in question, a vehicle, was directly used in the commission of a crime. That case, at least, maintained some connection to the historical rationale behind forfeiture laws." He paused, then made the crucial distinction. In Henderson, the property is real estate, specifically a community center, with only the most remote and speculative connection to any criminal wrongdoing. There were no charges filed against the owners. The seizure here represents a clear constitutional overreach, one that violates both the Due Process Clause and the Takings Clause, even under the logic this court applied in Bennis. Justice Thomas gave a small nod, his expression unreadable. But the significance of the exchange was clear. Washington had just met one of the court's most rigorous originalists on his own terms and held his ground. The court could easily distinguish Henderson from prior cases like Bennis, while reaffirming that civil forfeiture must be constrained by both constitutional principles and historical precedent. Washington's answer, which honored the court's institutional caution while advancing his argument, reflected a deep and strategic understanding of judicial dynamics. He wasn't merely delivering theoretical legal commentary, he was offering the justices a principled and workable path forward. By this point, Chief Justice Roberts was no longer focused on Washington's celebrity or credentials. He was fully engaged with the substance of his argument. Leaning forward, he posed one final question. "Mr. Washington, if we were to accept your framework, what specific test would you have this court adopt for evaluating civil forfeiture cases going forward?" It was a question of real consequence, typically reserved for the most esteemed legal advocates. It signaled not only that Washington's argument had been taken seriously, but that he was now being invited to help shape doctrine. Everyone in the packed courtroom felt the shift. The moment had become something more than a hearing. It was history in the making. Washington responded without hesitation. "Chief Justice," he said confidently, "I would recommend a three-part test grounded in original constitutional understanding and aligned with this court's recent rulings in Austin and Timms." He raised his hand and held up 3 fingers, counting off each element clearly and deliberately. First, Washington began, his voice calm and deliberate. The government must demonstrate a substantial connection between the property and the alleged criminal activity, not the flimsy, indirect association presented in this case. Second, he continued, if the property owner is within the court's jurisdiction, due process demands one of 2 things: either a criminal conviction or clear and convincing evidence that the owner had actual knowledge of and gave consent to the property's illegal use. Third, he said, lowering his hand, the forfeiture must satisfy the public use requirement, not by simply funneling proceeds into general government funds, but by directly addressing a specific harm to the public. He paused, allowing his words to resonate across the chamber. This framework, Washington concluded, his tone now carrying a quiet but undeniable authority, respects the text of the Constitution, aligns with historical intent, offers lower courts practical and principled guidance, and, most importantly, protects innocent Americans from one of the most intrusive exercises of state power, the seizure of their homes, businesses, and community centers without meaningful legal process. As he finished, the customary signal marking the end of argument time did not come. There was no gavel, no interjection, just silence. Instead of cutting him off, the justices remained motionless. Several were still jotting down notes. Others leaned back, visibly reflecting on what they had just heard. The gravity of the moment hung in the air. Finally, Chief Justice Roberts spoke, his tone now entirely transformed from the skeptical voice that had opened the hearing. "Thank you, Mr. Washington," he said with sincerity. "Your argument has been exceptionally informative." It was more than a compliment. It was a rare acknowledgement, one that signaled that what had started as an unconventional appearance had evolved into something historic. The Chief Justice's simple acknowledgement carried an unmistakable subtext. His earlier attempt to undercut Washington's credibility had not only failed, it had revealed a legal intellect of extraordinary depth, preparation, and clarity. As Washington calmly gathered his materials and returned to his seat, all eyes turned to the government's attorney, who approached the podium looking noticeably unsettled. The energy in the courtroom had shifted. What began as a seemingly routine defense of government authority had now morphed into a steep and sudden climb, one framed against a powerful constitutional argument that had resonated with justices on both ends of the ideological spectrum. Legal reporters present in the chamber sensed immediately that they were witnessing something rare, a turning point in constitutional law, and perhaps a challenge to the very conventions of who is seen as belonging in the legal profession's most elite spaces. The aftermath was swift and far-reaching. What quickly became known as the Washington argument spread like wildfire across legal, academic, and cultural circles. Within hours, professors at top law schools were assigning the transcript of the oral argument to their students. Social media buzzed with commentary from scholars, practitioners, and civil rights advocates alike. But more than just a landmark moment in legal theory, it had become a story of defied expectations, one that questioned long-held assumptions about background, merit, and belonging at the highest levels of constitutional debate. Constitutional scholars from across the political and academic spectrum weighed in, many expressing both surprise and admiration at the intellectual depth and precision of Washington's argument. Even seasoned analysts acknowledged the moment's significance. CNN's senior legal analyst Jeffrey Toobin offered perhaps the most concise summary. "I've covered the Supreme Court for over 2 decades, and I've never witnessed anything quite like this." Denzel Washington didn't just hold his own against the Chief Justice. He delivered what may be the most compelling originalist critique of civil forfeiture ever argued before the court. By the next morning, social media was ablaze. Hashtags like #LegalScholarDenzel and #DenzelTeachesTheChief were trending across platforms. Viral clips showed Washington referencing obscure Madison letters and reciting early American case law from memory, moments that quickly captivated millions of viewers. A generation that had grown up admiring Washington for his powerful performances on screen was now seeing him in an entirely new light, as a disciplined legal mind, challenging entrenched legal doctrine with grace and authority. Just 3 days after the argument, the New York Times ran a full-length feature that pulled back the curtain on Washington's years of quiet academic pursuit. The article detailed how, between filming blockbuster movies, he had completed a rigorous legal education, largely under the radar, culminating in what many now considered one of the most remarkable Supreme Court appearances in modern history. According to the New York Times feature, Denzel Washington earned his Juris Doctor from Howard University School of Law with highest honors, balancing late-night study sessions and weekend coursework while continuing to lead a demanding acting career. His professors described him as a standout scholar, particularly drawn to constitutional history and civil rights theory. He never sought special treatment, said Professor Marcus Johnson, who taught Washington in his constitutional law seminar. For the first few weeks, most students didn't even realize who was sitting beside them. He was just another driven student, though one with an undeniably commanding presence when he spoke in class. The article also revealed that Washington had quietly funded scholarships for law students from underrepresented communities, insisting his name remain anonymous in all program materials. His pursuit of legal education, it explained, had been born of a long-held commitment to justice reform and a sincere desire to contribute meaningfully beyond his celebrity platform. In the days following the oral argument, legal blogs and podcasts lit up with analysis. Thought leaders across the legal spectrum began dissecting every word of Washington's appearance. Much of the commentary focused on the striking transformation in the courtroom dynamic, especially the contrast between Chief Justice Roberts' initial, dismissive tone and the deep respect that emerged once Washington's command of the law became undeniable. What had begun as an unusual footnote in the court's docket had now become a defining moment in its modern history. Court observers noted a marked shift in Chief Justice Roberts' demeanor as the argument unfolded. What began with condescension gradually gave way to genuine engagement. By the end, Roberts was no longer addressing Denzel Washington as a novelty or outsider, but as an intellectual equal. What we witnessed, said NPR's Nina Totenberg on Morning Edition, was a live recalibration of professional assumptions. The Chief Justice clearly expected to encounter a dilettante and instead found a legal mind of rare depth. His transformation over those 50 minutes is a powerful reminder of how preconceptions still operate in the legal world. The ripple effects within the legal community were immediate and profound. The American Bar Association extended a formal invitation to Washington to deliver the keynote address at its annual national conference, an honor reserved for the most respected figures in law and policy. Meanwhile, law schools across the country reported a dramatic surge in interest. Applications from underrepresented minorities rose by 34% in the months following the argument, with many prospective students explicitly citing Washington's performance as a source of inspiration. What had begun as a test of one man's credibility had become a catalyst for broader change, challenging the gatekeeping norms of the legal profession and opening doors for a new generation of advocates. Throughout the whirlwind of media attention, Washington remained characteristically humble. When asked about the Supreme Court argument at an unrelated film premiere, he offered a simple, measured response. Law, like acting, rewards deep preparation. I'm grateful the court gave me the opportunity to present an important constitutional argument, and I hope their decision moves us closer to justice. 6 weeks after oral arguments in Henderson v. Department of Justice, the Supreme Court issued its ruling. In a stunning 7-2 decision, the justices sided with the petitioners, dramatically narrowing the federal government's authority to carry out civil forfeitures. The framework closely reflected the principles Washington had outlined. In a move that surprised many, Chief Justice Roberts authored the majority opinion, a gesture widely interpreted by legal analysts as a gracious acknowledgment of his initial misjudgment. After careful review of the historical record and constitutional text, Roberts wrote, "We conclude that civil forfeiture, as it has evolved, exceeds the boundaries originally envisioned by the framers. While forfeiture remains a legitimate tool in certain contexts, the Constitution does not permit the government to confiscate property from innocent individuals based on weak or indirect associations with alleged criminal conduct, particularly when, as in this case, the property serves vital community purposes." The ruling was immediately hailed as a landmark decision, one that not only reshaped civil forfeiture jurisprudence but also underscored the power of disciplined advocacy, regardless of the messenger's background. In a striking and unprecedented move, the Supreme Court's majority opinion quoted Washington's oral argument on 4 separate occasions, including his proposed 3-part test, which the court largely adopted as its new guiding standard. A footnote within the opinion offered specific praise to the Amicus Curiae Council, commending the exceptionally thorough historical research that shed light on the founding era's views on property rights and constitutional protections. Justice Clarence Thomas issued a concurring opinion that went even further, urging the court to undertake a comprehensive re-examination of civil forfeiture doctrine through the lens of originalist interpretation. Justice Sonia Sotomayor also penned a concurrence, highlighting the disproportionate harm civil forfeiture practices inflict on marginalized communities. She cited directly from the data Washington had presented during oral arguments to support her point. But perhaps the most remarkable moment came in the final paragraph of Chief Justice Roberts' majority opinion. Departing from his usual formality, he added a personal reflection. This case reminds us that legal insight can come from unexpected places, and that our system of justice is made stronger when diverse voices and perspectives are heard. The court was deeply enriched by the rigorous advocacy and historical scholarship brought forth by all participants in this case. The decision's real-world consequences were swift and profound. Within months, multiple states began reforming their civil forfeiture statutes to align with the court's new constitutional framework. Legal advocacy groups hailed the ruling as a turning point in property rights jurisprudence and a long-overdue course correction in protecting innocent citizens from government overreach. In the months following the Supreme Court's landmark ruling, property valued in the millions was returned to innocent owners and community organizations that had previously fallen victim to aggressive and often unjustified forfeiture practices. Law enforcement agencies, responding to the new constitutional standard, began redirecting their efforts towards seizures based on actual criminal convictions, moving away from the speculative claims that had long been misused. For Denzel Washington, the experience marked the beginning of a powerful new chapter in an already remarkable career. While continuing his acclaimed work in film and theater, he launched the Washington Justice Initiative, a nonprofit dedicated to providing legal support to communities affected by civil forfeiture and broader property rights violations. The initiative quickly became a leading force in grassroots legal advocacy. Prominent law schools across the country began inviting Washington to deliver guest lectures on constitutional history and jurisprudence. His blend of academic rigor and lived experience brought fresh insight to the classroom, inspiring a new generation of legal thinkers. 6 months after the Henderson decision, Washington appeared alongside Chief Justice John Roberts at a civic education forum hosted by Georgetown Law. Their conversation, filled with mutual respect and even moments of light-hearted reflection on their initial courtroom encounter, offered a public display of how honest legal confrontation, when grounded in preparation and integrity, can lead to deeper understanding. Roberts took a moment during the event to speak candidly. "Mr. Washington taught me something important that day, never to conflate celebrity with competence, and never to dismiss alternative paths to legal knowledge." His argument in Henderson will be studied in law schools for generations. It stands as a testament to what thoughtful advocacy, no matter its source, can accomplish. The forum ended not with applause alone, but with the quiet recognition that something lasting had occurred, not just a legal victory, but a redefinition of who can shape the law and how. Washington responded with his trademark composure and humility. The beauty of our legal system, when it works as it should, is that arguments are judged on their merit, not on who delivers them. "I'm grateful the court was willing to engage seriously with the constitutional questions in Henderson, regardless of the unconventional messenger who raised them." That brief but profound statement was shared widely across social media, cited in legal journals, and even included in orientation materials for incoming law students. It quickly became a symbol, an emblem of how assumptions can be dismantled through discipline, courage, and the willingness to speak truth to power. From classrooms to courtrooms, and in conversations across the country, the story of how a Hollywood icon earned the respect of the Chief Justice, not through celebrity, but through scholarly excellence, took on the feel of a modern parable. It was a lesson about perception, opportunity, and the enduring American pursuit of a legal system where substance transcends status and ideas matter more than identity. Thank you for watching this extraordinary account of Denzel Washington's Supreme Court triumph. If this story of justice, preparation, and unexpected brilliance inspired you, please hit the like button and subscribe to our channel for more powerful stories that challenge assumptions and celebrate perseverance. And we'd love to hear from you. Leave a comment below. How do you think preconceptions shape who we listen to and trust? How can we do better?